Hello again, everyone. Again, we're going to have our panel discuss IP from the angles of startups, developing and established organizations. Our first speaker is Mr. Ali Shah, who's a partner with Ali & Associates, a leading IP firm in Pakistan. He specializes in dispute resolutions and commercialization of IP and advises leading national and international companies on various IP matters and helps them develop further legal strategies. Mr. Shah is a member of many organizations in Pakistan and many international organizations, including the International Chamber of Commerce of Pakistan and the Asian Patent Attorneys Association. So without further ado, I'll welcome Mr. Shah, who will speak on the rise of parasitic copying and alternate competition law remedies in IPR disputes.
Thank you very much. Thank you, everybody. I know it's the last session of the day. It's always a little bit difficult. I especially want to thank IIPLA for having us here, and Donald for collating all the information over the holiday period, which is not the easiest thing to do. The purpose of the way that I'm going to start this presentation is really look at a couple of varying things, such as competition law and IP law, and then present a case study, something that's just gone through in Pakistan, which we've been dealing with, which is really a new and exciting sort of area of development, not just in Pakistan, but also in the UK, from where actually we've took the lead, where the brand, a couple of organizations have taken the lead, and whose lead we followed. Now, if we look at the relationship between IP law and competition law, there's a bit of tension in there, because on the one hand, competition law is obviously, their main focus is antitrust, trying to break up monopolies, ensuring that there's fair competition, while when we look at the IP law, it's all about trying to get a monopoly, That's what we do. That's why we register patents and trademarks and copyrights. But there is a confluence when we look at both of those. The concept of bad faith, that's present in trademark and copyright. That's something. Fair dealing is something that we again look at it in trademark law and in competition law. The other is the protection of consumers. This forms the basis of how trademark law really develops and how we go in for enforcement. We look at, will a consumer be deceived, right? And that's something that is there in competition law as well. The idea that consumers need to be protected. So there is a confluence, but there is a tension. Now, wherever these two areas meet is something that companies and IP owners can exploit. There is an alternate remedy that's available to us. One of the things that's happened in South Asia over the last 10 years is very rapidly in Pakistan, there's been urbanization, and the manner in which consumers interact with brands, that's completely changed. Your general stores, from where there would be an entire generation, since people who were young, they would live in the same neighborhood, number one, which is something that's no longer happens. You don't spend 30, 40, 50 years in the same neighborhood. You move, wherever your jobs take you. Those general stores would be where you would go and you would buy your groceries, and there would be an inherent inbuilt credit system, and you would take the advice of whoever the owner-operator of that general store. Now, that doesn't happen. That personal relationship is quickly eroding. What's happened is that we have the larger multinational retailers. They've come in. In Pakistan, we have European giants Metro, Carrefour. They've set up very large, big hypermarkets, as well as the local players. They've expanded. So that relationship has now become impersonal. Right? At the same time, consumers don't rely on that credit facility that a neighborhood store would otherwise have provided, because, well, they've got credit cards and they've got loans and they've got other sort of impersonal ways in which they can have all of those facilities. Now, that obviously changes consumer behavior. That changes the manner in which consumers interact with brands. And it's led to the disappearance in many areas of smaller general stores, those corner stores that, were really I think the basis of how brands would have interacted with any consumer. So while these changes are taking place, obviously brand owners, and especially the marketing departments of the larger corporations, they're aware of all of these changes. But sometimes what we find is that the legal departments aren't really keeping abreast of those changes, and perhaps the changes that have occurred in the law. We look at the rise of sensory marks. We look at the rise of, the manner in which color is being protected and how important that's become, right? When your brand identity, Walls, the Unilever is very specific about the way that they protect some of their sounds, or at least attempt to do so, right? Packaging, color schemes, fonts, all of these have become really important to protect from an IP perspective. Now, at the same time, I think I'll just go into from a startup perspective. One thing that we have to look at is startups are disruptive organizations. That's what they do. There is a niche, they go and they exploit something. Either they're very good early on in identifying something new, or identifying the changes in consumer behavior, and also or doing something a bit more efficiently and effectively that perhaps was not being done. Now, what do we mean by parasitic copying? And it's a concept that's just, over the last few years has really taken hold. Well, the British Brands Group, which have been working on this, fairly prominently, they look at it as parasitic copying, and I'll just read this from their little presentation, is used by competitors to boost sales by confusing and misleading consumers. Distinctive features of a familiar brand's packaging are hijacked in order to dupe shoppers into buying something they believe to be that brand. The competitor gets a free ride of the back of the brand's reputation, investment, and innovative efforts. The other thing is that, and especially when we talk about larger supermarkets, it's not just that they're trying to, dupe a consumer. What they're trying to do is that, look, this is very similar. This shampoo is very similar to the one that you're going to buy from this multinational corporation, but we're going to offer it to you for 50% less. Why don't you go for this? It becomes very difficult to take action at times under IP laws because they'll skirt infringing IP. The bottles will be similar, the color will be similar, but at the same time, what we'll see is that it may not necessarily constitute IP infringement. And these are a few examples. And these are a few examples which have not been successful, perhaps, as trademark matters when they've been taken forward. So, these are prominent brands, and you can see, the shape of the bottle is similar. At the same time, Boots would argue that, look, our trademark's fairly well known. We don't, when a consumer goes in, they know what Head & Shoulders is and what Boots is. They're in our store. So they can make that distinction. And they're kind of right. The consumer does make a conscious effort to pick that. But the fact that you're trying to piggyback on somebody else's reputation, that's really at the heart of parasitic copying. Now, the European Commission conducted a study. I think Norton Rose Fulbright were a lead in that. And they categorize what effects parasitic copying has. So the first effect that they said, at least some of the consumers who purchase product B do so on the assumption that they're purchasing product A. So there's direct confusion and deception. The second thing that they look at is that same commercial origin, that perhaps, ultimately they have the same formulas, ultimately they're the same sort of product. So it's at the back of their mind. The third effect that they looked at was that there's an assumption that products A and B, while having different commercial origins, are substitutes. Here's the thing, here's the key, that they're substitutable. So you're not creating a brand identity, but what you're saying is, there's a brand, you know it, you interact with it, here's our substitute. I touched on this briefly, but from startups and brand identity, I think the pace in which startups move these days, Uber is a great example of that, Alibaba, these have become global organizations within a number of years. I mean, we're not talking about decades, we're talking about 3, 4, 5 years, and these have become global organizations. Like I said, they're disruptive. What they tend to do is explore new ideas, new areas. In the previous session, I think Hadi had talked about that startups are a little bit weak on the IP side. And you can understand why. Much of their legal work is being done on financial structuring, etc. They want investors. They're looking at the equity side of it, that perhaps they don't focus on IP. Perhaps technology companies might be a little bit different in this because they're only focusing on IP so that they can be taken over. But otherwise, that's a weakness that gets exploited by perhaps better established firms. Another thing that I think Nevin also looked at it was, I think, PCT filing, but I'll sort of, there's a comparable here in that when you're starting up, you might be starting up in the US, but you don't know that you might, I'm from Pakistan. There are 200 million people. Your product, even though Pakistan's on the periphery, you're not even thinking about it at that moment. 3 years down the line, it might become a major market, and you may not have protected yourself. So it's really difficult for startups because, number one, they don't have that cachet of knowledge that an established organization like Nestle would have, because they've dealt with various different issues in different countries and built up that knowledge. They know how to tackle these things. A startup might not have that, and they might not have the necessary personnel. Like I said, that IP councils, they may not have IP councils, and or the fact that they don't know which countries they want to enter into. So that's a real big issue for startups, and especially in this idea of when they're trying to create a brand identity and how to protect that brand identity. This is where competition law, at least in Pakistan, has come to the rescue. In 2010, we passed a new Competition Act, and what competition law really looked at was, they didn't look at registration of IP, they didn't really look at how, what constitutes infringement. What they looked at is there a trademark? And there's a broad definition for what a trademark can be. And is somebody trying to exploit it, number one? Number two, are two companies not behaving in a fair manner with each other? Now, those are very broad general rules, but that's, that allows us to exploit them in a positive way for our clients. The other thing is that IP litigation and litigation in general in Pakistan can be long, it can be a very arduous process. There are just certain structural issues that, civil litigation just takes a very, very long time. And at the end of that, you don't get costs. So it becomes very difficult. So the only thing you're really going for is an injunction, and that too at an early stage, which can only really happen if you have a very discernible right that is being infringed. With competition, with the Competition Commission, they don't really look into, again, registration of IP. And the other thing that they're not really looking into is, the positive of it is that they actually do grant damages, and in the millions of rupees and millions of dollars. So that's a real big advantage for companies to, have an alternative to going through the civil litigation process. The case study that I want to look at is, it's very two big established Pakistani companies. One is Dawn Bread. Dawn Bread is, everyone in the past 3 generations of Pakistan have grown up eating this bread. It's, wonder bread for the Pakistan market. The other is K&N's. Now, K&N's is an interesting history. It was a poultry company for about 40 years. Then about 7, 8, or 10 years ago, they decided to enter into a very new area, which was frozen foods. And now, they were not in the commercial sector at all. On the other hand, Dawn was. So they were coming in. They had evaluated that, look, consumer habit is changing. There's an urbanized, younger population. Perhaps, if everyone's working, if people are married, both partners are working, they don't have that time, frozen foods is going to catch on. And they really went in fairly strongly and developed a $250 million revenue base out of that. Dawn, even though had a very larger commercial base, had not seen this sector, and in fact, a lot of companies didn't. This is where K&N, even though it's an old company, was in fact a startup, because it entered into a commercial area of operation where nobody else was really trying to exploit. So they came out with these, the kofta kebabs. This was their packaging, and the onus of their packaging very strongly was on the color red. Now, Dawn, what had they done about 4 years ago, they launched the similar product in a different packaging, then decided, hang on, this isn't really working. Why don't we amend our packaging? And they came up with this packaging. Now, one thing to remember at this stage, that K&N, with this packaging, they had not protected the color red, so there's no registered trademark for red at this stage. All of their focus on as far as IP protection was on their logo, as well as their trade name, K&N's. That's it. So when we go into this, when dealing with this issue, the biggest challenge for us was that we're not dealing with a registered trademark. And if we were to go to the civil courts, the chances were that we would not have gotten an injunction. And it would have just gone for a very long time in there. Perhaps we'd have been able to, convince them about 3, 4 years, 5 years down the line, and then there wouldn't be any damages. By which time that exclusivity that had been built would have really eroded. So as you can see, there's a clear similarity. But now one of the other component, the other reason why there was a problem with regards to under trademark law was that nobody in Pakistan is going to confuse the two, because of the fact that Dawn Foods, everyone knows, everyone's grown up with Dawn, right? So there's a brand identity, both of them have clear brand identities. But it gets complicated when you look at the manner in which now consumers are identifying with the brand. It's that visceral idea that you actually just look at a product and you're like, hang on, I know that product. And that's what gets built up. I'll just go back to the start of my presentation, which was on the changes in the retail environment, and with the erosion of the smaller stores. In these larger hyper stores, all of these products are kept in giant freezers, and as you can see, all of a sudden what you have is that exclusivity, that goodwill that you've built, that brand sort of loyalty that comes with knowing that, oh, that red, I associate that. That gets eroded when another entrant comes in and then just uses the same sort of color. So, these are a couple of just photographs of the two packaging, and as you can see, they're very, very similar, and it's very hard to, create that identity in a store. You're in a giant store and you're like, look, we want this section to ourselves. Right next to that is a competing product. And all of a sudden, all of that effort of yours has just gone to waste. So anyway, we filed a complaint with the Competition Commission, and we really relied on a component of the Act, which under Section 10(2)(d), which says that no undertaking shall undertake deceptive marketing practices, and that fraudulent use of another's trademark, firm name, or product labeling or packaging would constitute deceptive marketing practices. Now, trademark's not defined in that. None of the other terms are defined, and this is a new area of law. The Act came out in 2010. Before that, there was no concept of protection of consumers through competition measures. Before that, it was even the Competition Commission of Pakistan was called the Monopoly Control Authority. Anyway, after protracted sort of an inquiry, one of the other advantages, let me just highlight, of this process is that unlike civil litigation, under the Competition Commission and the way that the Competition Commission works, they conduct their own inquiry. So they have inquiry officers, they'll go out in the field, and so rather than having that discovery phase, you have these investigators on the role of the CCP, and they will go and they will conduct an inquiry and produce an inquiry report on the basis of which action will then be taken. So this is still ongoing, this matter, but the inquiry reports now come out. Number one, they accepted the fact that the color red would constitute a trademark, which is, it's not a registered trademark, so we wouldn't have been able to go through perhaps with civil courts. But here they realize that, look, the color red can be a trademark, and that the use of this trademark by a competitor would constitute deceptive marketing practices. And under that, what they have done is that, this is a fairly lengthy sort of conclusion on their part, but they have said that there appears to be a prima facie violation of the Act, and that proceedings should now be initiated, which have been initiated, and the members are looking into it, and we are fairly confident of a positive outcome. I think just wrapping up, I'll just wrap up. When we look at brand identity and in these sort of competing and very sort of challenging sort of times, because when we look at Pakistan, I think we're looking at there are certain structural issues in existing, in the courts, etc. But at the same time, what we have is a great potential because of the kind of market that we have. We have a very young market. We have a very rapidly urbanizing populace. And what that does is it provides an opportunity. It provides an opportunity for startups, and it provides an opportunity for established businesses trying to enter a new space. One of the things that needs to also be done is being aware of changes in the law which may actually benefit your organization. Right. Thank you very much.
Thank you, Ali. It was very interesting to hear about the competition law in Pakistan. I don't think we have anything similar to that in the United States, and I'd be interested to talk a little bit more about the comparison with the trademark actions and such, and if maybe you could simultaneously do both.